Welcome to the 2021 White and Case Jessup Cup World Championship. Congratulations to the two teams who will be arguing in today's final round. Representing the applicant from Singapore, the National University of Singapore. And representing the respondent from Australia, University of Sydney. After the arguments from the two teams, and while the honorable judges deliberate, we will be debuting a special virtual Go National photo collection showcasing our 2021 Global Rounds Jessup teams. So please stay tuned for that following the initial adjournment of the court. We are honored to be welcoming a very distinguished panel of judges from the International Court of Justice, Judge Tomka, Judge Shui, and Judge Iwasawa. Best of luck to both teams. The session will begin momentarily.
All rise. The International Court of Justice is now in session. The judges are now entering the courtroom. The case before the court is the case concerning the COVID-18 pandemic. The parties are applicant, the United Republic of Apropluia, versus respondent, the Democratic State of Ranavstayo. The applicant and the respondent are each allocated 45 minutes to present their pleadings. The president of the tribunal will invite applicant to begin momentarily.
Good afternoon. I declare open the sitting of the court. The court meets today to hear the oral arguments of the parties in the case concerning the COVID-18 pandemic. The proceedings were instituted by application filed on 12th of July 2018 by the United Republic of Apropluia against the Democratic State of Ranavstayo. The parties filed the written pleadings within the time limits determined by the court in its order of 11 September 2020. The case is ready for oral arguments. I note the presence of agents, co-agents, counsel, and advocates of both parties. So I invite now the agent for the applicant, the United Republic of Apropluia, to address the court. Your Excellency, you have the floor.
Apologies, we're having some technical difficulties. Your Excellencies, am I audible?
Yes, we can hear you well. Madam Law, you have the floor. Please address the court.
Mr. President, Your Excellencies, may it please the court. My name is Bei Jia Wei, and together with my co-agent, Ms. Rebecca Liu, we appear for the applicant, the United Republic of Apulia. We will each speak for 21 minutes and reserve 3 minutes for rebuttal. Your Excellencies, there are 4 issues before this court. First, can run-of-style impose a statewide entry prohibition on Apulia when Apulia had fewer than 10 JVID-18 cases confined to 1 laboratory in 1 province that was under lockdown? Second, can run-of-style persist in harboring Ms. Formund within its consulate when she was charged with 3 domestic crimes? And third, can run-of-style insist that this court has jurisdiction over its counterclaim when it concerns matters excluded by Apulia's reservation? And fourth, can Apulia be held liable for downing an aircraft that posed a terror threat to its capital city? I will speak on the first 2 issues, my co-agent on the third and fourth issues. Turning then to the first submission, we make 2 arguments. 1, run-of-style violated international law by imposing its entry regulation on Apulia. And 2, it is consequently liable to compensate for the resulting economic losses. And Your Excellencies, when we recognize that every state has the sovereign right to implement its own health measures, this right is not unfettered. In this regard, Article 43, Paragraph 1 of the International Health Regulations provides that a state's health measures, which go beyond WHO recommendations, must not be more restrictive of international traffic than reasonably available alternatives that would achieve the appropriate level of health protection. And here we submit that under Section 1 of run-of-style's regulation, at paragraph 10 of the facts, its statewide entry prohibition on Apulia was excessively restrictive of international traffic and therefore in violation of Article 43(1) of the IHR. And Your Excellencies, this is because there were several less restrictive alternatives that run-of-style could have adopted, which would have achieved its appropriate level of health protection, which was to minimize the risk of entry and spread of JVID-18 in run-of-style. And chiefly, Your Excellencies, we submit that the alternative that run-of-style should have adopted was to limit its entry prohibition to only Segura province, where the only cases were detected. And this, Your Excellencies, would be consistent with the practice of states in the COVID-19 pandemic, where countries such as Japan, Singapore, Philippines, and New Zealand had placed province-level entry restrictions in the initial stages of the outbreak. Entry bans were limited to places with COVID-19 cases, such as Victoria in Australia, Northern Italy, and North Gyeongsang in South Korea. However, Your Excellencies, what run-of-style did was to impose a statewide entry prohibition on Apulia. And this, we submit, violated Article 43(1), given the state of affairs in Apulia at that point in time. Now, when run-of-style imposed its entry prohibition on the whole of Apulia on 8th June 2018, there were merely 9 cases out of a population of 3 million, and these 9 cases were confined to a single laboratory in a single province. And right after the first two cases were confirmed, we know from paragraph 27 of the facts that Aprilia isolated these individuals and all of their potential contacts with immediate effect, halted operations at the national laboratory, and locked down the whole of Segura province on its own volition. In light of these factual circumstances, we submit that a statewide entry prohibition on the whole of Aprilia was excessively restrictive of international traffic, as run of style should have limited this prohibition to only Segura province. On this basis, we submit that run of style was in violation of Article 43(1) of the IHR. And Your Excellencies, yes,
Excuse me, Agent. When you discuss excessively restrictive, you invoke the test of a less restrictive alternative. Where does this test, less restrictive alternative, come from?
Your Excellency, the test of a less restrictive alternative is derived from Article 43(1) of the IHR. And what is required is for the alternative to be significantly less restrictive than the measures adopted by run of style. And this was stated by the World Trade Organization appellate body in the 2015 case of India agricultural products at paragraph 5.203. And Your Excellencies, yes.
Excuse me. What implications and relevance does the jurisprudence of the WTO have for this court?
Your Excellency, we submit that the relevance of WTO jurisprudence pertains to the interpretation of the terms in the IHR. And this is because Article 5.6 of the Sanitary and Phytosanitary Agreement is similar to Article 43(1) of the IHR. And states parties of the IHR contracted for the terms in the SPS agreement and the IHR to be interpreted consistently. This is clear from the 2004 Intergovernmental Working Group's report on the relations of the IHR with other international instruments at paragraph 9. And therefore, Your Excellency, we submit that WTO jurisprudence on the SPS agreement, in particular, Article 5.6, is relevant in interpreting Article 43(1) of the IHR. And here we submit that the test of significantly less restrictive was met on the alternative, because this would mean that there would be no outright statewide prohibition on the whole of Aprilia, and this would therefore satisfy the test of significantly less restrictive. With that, Your Excellencies, we submit that run of style was in violation of Article 43(1) of the IHR by virtue of imposing a statewide entry prohibition. And accordingly, we submit that run of style is obligated to compensate Aprilia for the resulting economic losses. And this follows from the general principle of international law that there is an obligation to make full reparation for the injury caused by an internationally wrongful act. And this was articulated in the seminal decision of the predecessor of this court in the 1928 causal factory case. We further submit that on the facts, a sufficiently direct and certain causal nexus was present, as evidenced by the report at paragraph 46 of the facts, which concluded that run of style's entry regulation had resulted in over 130 million euros lost in revenue by Aprilia. And indeed, Your Excellencies, we know from paragraph 3 of the facts that Aprilia has historically had an active tourism industry, drawing an average of 9 million tourist arrivals and gross tourism receipts of 7.5 billion euros every year. On this basis, we submit that causation was met on the facts. And this is further supported by the fact that 80% of all tourists in Aprilia left the country prematurely, and this we see at paragraph 30 of the Statement of Agreed Facts. And further, a proportion of those tourists stated that the reason why they were leaving was because they had flight connections in run of style or were from run of style, and therefore were afraid of this regulation's impact on their ability to return to run of style or their respective home countries. Therefore, we submit that causation was borne out on the facts, and run of style must compensate Aprilia for the resulting economic losses. Now, if Your Excellencies have no questions on the first issue, I now turn to my second submission.
Excuse me, Agent. In discussing this issue, you invoked international health regulation, but nothing else. But is the IHR is the only basis on which you argue violation of international? Thank you.
Your Excellency, it is our primary submission that Article 43.1 of the IHR was violated. However, we do also submit that run of styles measures in differentiating between non-nationals and nationals was discriminatory, and therefore simultaneously falls afoul of Article 42 of the IHR, as well as Article 26 of the ICCPR. In light of that, we submit that run of style has violated several international obligations. Your Excellencies, with that, I now turn to my second submission, that run of style violated the customary duty of non-intervention in persisting to harbor Miss Formund within its consulate when she was charged with 3 domestic crimes. Now, run of style's refusal to surrender this prosecuted individual, in the words of this court in its 1950 asylum case, withdraws the offender from the jurisdiction of the territorial state, in this case Aprilia, and constitutes an intervention in matters which are exclusively within the competence of that state. Now, against this, we note that the respondent has contended at pages 12 to 18 of its memorial that asylum can be granted if an individual's liberty would be arbitrarily deprived. However, we submit, Your Excellencies, that this is misconceived, because the respondent is unable to show widespread and uniform state practice in support of this customary exception. In fact, Your Excellencies, state practice shows otherwise. First, concerning Ecuador's granting of diplomatic asylum to Mr. Julian Assange in its embassy in 2012, states such as Sweden and the UK have viewed this asylum as unlawful. Now, Ecuador had granted asylum as they feared that Assange would be extradited to the US, where he purportedly faced the risk of being subject to unfair trial and the arbitrary deprivation of his liberty for leaking documents of possible war crimes committed by the US military during the Iraq War. Yet, Your Excellencies, in the words of Foreign Secretary of the UK, and I quote, "The UK does not accept the principle of diplomatic asylum. It is far from a universally accepted concept." And more recently, Your Excellencies, just last year in October, Hong Kong political dissidents charged for their participation in the protest movement were turned away by the US consulate. The US State Department stated unequivocally that these dissidents could not claim asylum in America's overseas missions and could only do so within the territory of the US, because otherwise the territorial sovereignty of a state would be compromised. Therefore, Your Excellencies, we submit that there is no legal basis for run of style's persistence in harboring Miss Formund within its consulate. Yes, Your Excellency.
Excuse me, Agent. In international law, do you distinguish diplomatic asylum and temporary sanctuary?
Your Excellency, indeed, there is a distinction. And according to Professor Eileen Denzer, this distinction between diplomatic asylum and temporary sanctuary lies in the fact that the grant of diplomatic asylum involves negotiating for safe passage out of the country, whereas temporary sanctuary is only afforded to an individual if the person's life or liberty is at stake for a temporary period of time. However, Your Excellencies, here we submit that regardless of whether this was a situation of temporary sanctuary or diplomatic asylum, state practice does not support that there is a customary exception to the non-intervention rule, given how states have treated individuals who sought asylum or sought sanctuary at their premises. However,
Agent, in your view, even temporary sanctuary is in violation of international law, or you think it's permitted under international law? I just want to make it clear.
Certainly, Your Excellency. In our primary submission, temporary sanctuary is also not recognized at international law, given, for instance, state practice that I cited earlier regarding the U.S. consulate's rejection of an individual seeking temporary refuge within its consular premises. Now, Mr. President, I note that you have a question.
Yes, I have a question, yeah. Because one question is to grant temporary refuge or diplomatic asylum, but in order to establish a breach, you need to point to the obligation of a sending state. Where is that obligation that the state cannot provide sanctuary in its diplomatic premises or consular premises? Where is that obligation stipulated in international?
Your Excellency, we submit that this obligation is the obligation not to intervene in the domestic affairs of a state. This obligation was found in the 1950 asylum decision by this court at page 275, in which this court stated that doing so, that harboring a prosecuted individual would effectively withdraw this individual from the jurisdiction of the receiving state. Yes,
Yep.
Your Excellency.
Can I interrupt? But can you more generally define and explain the conditions on which a certain act constitutes an intervention in internal affairs of a state? More generally, can you define and explain the conditions?
Your Excellency, we note that the definition of intervention in international law was articulated by this court in the 1986 Nicaragua decision, in which the element is that of coercion. This was stated at paragraph 205. And according to Oppenheim's international law at page 432, coercion is defined as interference that is forcible or dictatorial, in effect, depriving the state intervened against of control over the matter in question. And here we submit.
I apologize for interrupting you, but was here in this case forcible? There was no force used by sending state or consulate of that state when they accommodated in the consular premises a person fleeing persecution or being afraid of being persecuted for providing information.
Your Excellency, indeed, we acknowledge that no tangible force was used. However, the concept of forcible was defined by Oppenheim as, in effect, depriving a state of control over its internal affairs. And here, Apropria was deprived of the control over its domestic criminal justice process over Ms. Formund, who was its own national, as Ranastayer's harboring of Ms. Formund within its inviolable consular premises put this prosecuted individual out of reach of Apropria's domestic criminal justice system. Now, Judge Xie, if I may turn now to our alternative submission regarding the situation where there is some state practice where states do afford sanctuary or asylum if an individual's life or liberty is at stake. Now, here we submit that even if such an exception exists, this was not engaged on the facts. And rather, Ms. Formund was reasonably prosecuted for 3 domestic crimes, as you would see at paragraph 32 of the facts. Now, Ms. Formund was an individual who was put through Apropria's domestic criminal justice system. There is no evidence to suggest that the prosecution's charging and sentencing position was a foregone conclusion before the Aproprian courts. the appropriate courts have not even begun to hear Ms. Forman's case and could very well have disagreed with the prosecution's decision. And therefore, we submit that run-of-style's actions prevented this very criminal trial from happening and thereby intervened in the domestic criminal justice system of Aprilia. And even looking at the prosecution's position, Your Excellencies, on the available evidence, there is a reasonable basis for these charges and the sentencing position, which were at all times either specifically stated in the non-disclosure agreement at paragraph 6 or within the Aprilia Penal Code. And first, Ms. Forman had violated the governmental non-disclosure agreement by publicly tweeting about information concerning the laboratory. This was an express contravention of the terms of the agreement she had signed well in advance, which even made express reference to the possibility of being prosecuted. And Your Excellencies, we submit that this court must remember that Ms. Forman's tweet at paragraph 18 came in the midst of a pandemic, alleging the existence of JVID-18 cases within Aprilia territory at a time when these cases were not confirmed. And the alarmist character of her tweet could well have caused public disorder and public panic. In light of the seriousness of Ms. Forman's offenses, we urge this court to find that even if a humanitarian exception exists, the prosecution's position was reasonable, and therefore there was a breach of the non-intervention rule. Your Excellencies, unless I might be of further assistance, may it please the court.
Thank you. Thank you very much. And I now call on your co-agent to take the floor and address the court on 2 remaining issues. Thank you.
Mr. President, Your Excellencies, may it please the court. My name is Rebecca Liu, and I will be making 2 submissions today. My first submission concerns whether this court has jurisdiction over the counterclaim. My second submission concerns the merits regarding the lawfulness of Aprilia's shooting down of the Manson aircraft. As these submissions are the alternative, should Your Excellencies agree with our first argument on jurisdiction, then this disposes of the counterclaim in its entirety, and there is therefore no need to consider our second submission on the merits.
Yeah.
Turning to our first submission, we say that this court has no jurisdiction over the counterclaim because it is excluded by Aprilia's reservations. If Your Excellencies could please turn with me to the facts. At paragraph 48, we will see that Aprilia has consented to the court's jurisdiction under Article 36(2) of this court statute. However, if we look further down below, at paragraph 49, we will see that this consent is qualified by 2 reservations. 1, Aprilian military activities. 2, matters essentially within Aprilia's domestic jurisdiction. In our submission, the last sentence, which reads, as determined by the government of the United Republic of Aprilia, only attaches to the reservation on domestic jurisdiction. Now, turning then to apply this reservation on domestic jurisdiction, we note that the respondent in the memorial seeks to invalidate this reservation for contravening Article 36(6) of this court statute, which embodies the competence principle. We say this is misconceived. As articulated by this court in its 1953 Nottebohm case at page 119, Article 36(6) gives this court the power to examine the instruments that give rise to its jurisdiction. And indeed, as elaborated by Judge Crawford in his 1980 article on the legal effects of automatic reservations, What this means is that the court can factually determine the existence of its jurisdiction. And our reservation, Your Excellencies, does not deprive this court of its adjudicatory function, since it is still the final arbiter as to whether we have invoked this reservation as a matter of fact. And Your Excellencies, we have, having considered the matter to be essentially domestic, even before Ronald Styles' counterclaim was filed. Now, this can be found in paragraph 45 of the facts. Furthermore, we do accept that this court can review whether our reservation was invoked in good faith. And this test of good faith was indeed articulated by Judge Reed in his dissenting opinion in the 1957 Norwegian Zone case at page 94. Here, Your Excellency, the circumstance...
Tell me, what is the, sorry, I apologize. What is the value of dissenting opinions? These are sometimes lonely voices. Majority opinion was different. And
Yes,
you're now relying on the distinguished Canadian judge who produced the dissenting opinion. And you would like to present his view as an authority.
Your Excellency, Mr. President, my apologies. Well, we do note that this was indeed a dissenting opinion. However, it is nevertheless persuasive and can be considered under Article 38(1)(d) of this court statute. Now, in relation to the specific majority opinion in the 1957 Norwegian Loans case, the court never actually made a pronouncement as to whether the self-judging clause in that matter was valid. So we say that Judge Reed's opinion is to a certain extent still consistent with the majority opinion. And indeed, the principle of good faith is a general principle of international law, which has been recognized as important in the optional clause system, particularly by this court in its 1983 Nicaragua case at paragraph 60. And applying this test in turn, we submit that the circumstances show that the matter transpired in Apapluian territory and also exclusively concerned Apapluian nationals and instruments. And in that regard, we could consider the matter to be essentially domestic. And if the respondent does seek to allege bad faith on our part, then the burden lies on them to prove that, Your Excellencies. And therefore, we submit that the court does not have jurisdiction over the counterclaim in light of our reservation on domestic jurisdiction.
So your argument is that because your government considers that this is essentially domestic matter, we have no jurisdiction, yeah? Can we come to a different conclusion if we can review in good faith invocation of that reservation? Or to refer to another judge, a former colleague of Judge Reed, whom you mentioned, Judge Lauterpacht, he considered these kind of reservations invalid in a different opinion, yeah? Could you elaborate whether we can, despite the fact that you qualify this as essentially domestic matter, come to the different conclusion? And what would be the basis for our power to do that? Thank you.
Thank you, Mr. President. This court can come to a different conclusion if it sees that we have not invoked this reservation in good faith. Now, we do note that Judge Lauterpacht, in a separate opinion in the 1959 Interhandel case, stated that such a reservation could not be invoked in good faith. And that was because it was dealing particularly with the US's Connolly Amendment reservation, in which the US, in its 1960 letter on 23rd of May, deposited to the registry of the court, did expressly state that notwithstanding the impropriety or the arbitrariness of that determination, the court could not review such a matter. But our position is different, Your Excellencies. We do accept that this court can review whether the reservation was made in good faith by looking at the circumstances as well as the manner in which we invoked the reservation. However, if Your Excellencies are not minded to find that the present dispute falls within this reservation, Then we turn to our alternative submission. Here, we submit that the counterclaim falls within our reservation on Afro-Peruvian military activities. And on its plain meaning, a military activity involves the use of military instruments for the protection of the state's territorial integrity. This definition we gleaned from Judge Jessus's separate opinion in the 2019 International Law of the Sea case between Ukraine and Russia at paragraph 15. Here,
But where was this, where was here the threat to territorial integrity requiring a military action? At least in your qualification that it was a military action. Huh?
Mr. President, in our submission, our use of military instruments was to send off an imminent terror attack, as was reflected in paragraph 42 of the facts. Your Excellency, in the particular situation, we were faced with a potentially bomb-laden civilian aircraft. In light of the Interpol report, it can be found at paragraph 38 of the facts. And that is why we say the present case was a military activity, not just because it involved the use of military instruments, but the purpose for which these instruments were employed was to send off this terror attack. And therefore, this was an appropriate military activity, and this court has no jurisdiction over the counterclaim. However, even if this court does find jurisdiction, we are happy to turn to the merits of our case. And here we submit that Afro-Peruvian did not violate international law by shooting down the Mantian aircraft. Here, we note that the respondent's principal contention is that we breached Article 3 Bis A of the 1944 International Convention on Civil Aviation. This obligation requires states to refrain from using weapons against civil aircraft in flight. But there are two reasons why we did not breach this provision. First, it does not apply. It only governs aircraft of an international character. Second, and in the alternative, because Afro-Peruvian was lawfully acting in self-defense pursuant to Article 51 of the United Nations Charter. Now, the first point to be
What are the conditions for successfully invoking self-defense under the Charter of the United Nations? Could you remind this court about the conditions stipulated in Article 51 of the Charter of the United Nations for invoking successfully self-defense?
Certainly, Mr. President. In our submission, the conditions are that they must be necessary and proportionate and in response to an imminent armed attack. But our primary submission here is
there any other condition?
Your Excellency, apart from necessity and proportionality and the presence of an imminent armed attack, we would submit that there are no other conditions, Your Excellency, even though we do acknowledge that the respondent's argument is that Article 51 must be only invoked against armed attacks by state actors and cannot be invoked in an anticipatory fashion. And perhaps with that interest, Mr. President, I would turn to my submission on Article 51 of the UN Charter.
Article 51 also provides that a state which has taken action in self-defense has to notify the Security Council.
Yes, Mr. President, my apologies for that. And we have fulfilled that requirement as can be found in the clarifications, specifically at clarification number 5. Your Excellency, Chair, my apologies, do you have a question?
Yes, Agent, thank you. I'd like to follow up on the President's question. Previously, you argued this is a matter lies entirely with your domestic jurisdiction. Do you think in that case, Article 55 applies?
51.
51 applies?
Yes, Your Excellency, it does. And this is because we note that Article 51 has been invoked in domestic context. And therefore, for instance, in the 2004 Wall Advisory Opinion, we do note that Israel invoked Article 51 in response to threats, notwithstanding that it emanated from their own territory. And in that regard, we say that we also validly invoked Article 51. And this submission is an alternative one if we do accept that Article 3 bis does apply, which we don't, Your Excellency, for clarity. Your Excellency,
if I may interrupt you, could you repeat your argument based on the position of Israel
Your
in the whole
Excellency,
opinion?
certainly, Mr. President.
Yeah, please.
In our submission, Israel did invoke the right of Article 51 within their own domestic territory, which therefore goes to show that Article 51 can also be invoked in a domestic territory, and therefore our submission in respect of issue 3 is still valid, that this was an essentially domestic affair. But
territories on the west coast of Jordan River are the territory of Israel?
yes,
Because the international community considers this to be occupied territories, Palestinian territories, occupied territories. And the wall was to separate these territories, at least, from international recognized territory of Israel.
Yes, Mr. President, that is correct. But in any case, in respect of issue 4, this is an alternative submission, having accepted that this was not an essentially domestic affair, and having accepted that this court has jurisdiction over the counterclaim.
Mm-hmm.
And Your Excellency, our first argument in respect of the fourth submission is that Article 3 bis, which is the primary contention of the respondents, cannot apply in the present matter because the very title of the convention makes clear that it only governs international civil aviation and not domestic civil aviation. And indeed,
let me interrupt, but the convention was adopted in 1944. Article 3A was added much later, 40 years later. Can you use the title of the convention for the interpretation of article which was added to that convention in light of the experience, a particular accident, shooting down of an aircraft earlier in 1984, I think?
Mr. President,
what's the relevance of the title for the text of this article, which is the amendment addition to the convention?
Mr. President, we would still submit that the title is indeed relevant when one applies the interpretive principles under Article 31(1) of the VCLT, which states that when interpreting a provision, regard must be had to the context of the provision. And Article 3 bis is contained in the Chicago Convention, which only governs international aircraft. And here we submit to Your Excellencies that given that this was an Appropriate registered plane, remained in Appropriate territory at all material times, the unilateral intention on part of the pilot of the plane cannot make the flight international. Here, however, even if we do accept and take the respondent's case at its highest, we say there was no breach of this provision because we were lawfully acting in self-defense pursuant to Article 51 of the United Nations Charter. And following 9/11, state practice evinced that Article 51 could apply, first, as against armed attacks by non-state actors, and this was evinced in Security Council resolutions 1368 and 1373, and second, that it could also apply in anticipation of imminent armed attacks. And we can see this affirmation from as recent as the 2021 ARIA formula meetings by more than 10 states. As such, we submit that the critical inquiry before this court is whether we did in fact face an imminent armed attack and whether we responded in a necessary and proportionate manner. And we
excuse me, Asian. Can I ask you a question? In this context, how would you describe this as an armed attack? Why you define this as armed attack?
Certainly, Your Excellency. Now, pursuant to this court's holding in its 1986 Nicaragua case, specifically at paragraph 191, An armed attack must be of a sufficient gravity and scale. And here, the threat that we were confronted with was of a potential bomb-laden civilian airplane. And what this could have meant would be that bombs would be dropped all over our capital, or that the plane could have crashed into key buildings. And on either construction of the event, the effects would have been catastrophic. And Your Excellency, it is critical to note that Bhutan, the capital of Apulia, houses Apulia's banking and financial sector, which is a key contributor to our GDP. So any attack on our capital would have been catastrophic, Your Excellencies, and this would also, in all probability, lead to the loss of lives. And that is for those reasons that we submit that we did face an imminent armed attack. But beyond the interpolar force, which I've earlier referred to, we note that this plane on the 26th of June took off from Segura province at a time where the province was on complete lockdown and no flights should have been in the air. Now this plane remains completely unresponsive for 15 whole minutes, despite numerous attempts of communication and sending interception signals. It bears noting that we even fired traces across its flight path, Your Excellency, but to no avail. And Your Excellencies, it was only when this plane was just 3 minutes away from our capital that we eventually used force. But this force was never to force the plane to crash.
Excuse me, Agent. For your argument that the right of self-defense can be invoked for unarmed non-state actors, you gave some authorities, but can you give us more authorities to support your argument? Thank you.
Certainly, Your Excellency. Now, we do note that Israel in 2006 did invoke Article 51 against Hezbollah, and this was expressly supported by more than 18 states. But beyond that, we also note more recently in 2015 that Article 51 was invoked against ISIS by more than 15 states, like the UK and France, Your Excellency, and more recently in the 2021 ARIA Formula meeting, more than 16 states, such as Estonia and Latvia, expressly affirmed the right of Article 51 could apply against non-state actors. And for those reasons,
I apologize, but here you have invoked examples involving organized groups. You refer to ISIS, to Hezbollah. In your case, there was just one single plane. Did you have any evidence that that was part of an organized group? Because you use non-state actors in plural, so there should be more actors involved, not just one.
We agree, Mr. President, and we refer to paragraph 38. I do know my time has elapsed. If I could answer your question, Mr. President.
Complete the argument.
Thank you so much, Your Excellency. Now, in our submission, this was not a single plane. At paragraph 38, the threat that we were forewarned about was of a transnational terrorist group, the FOJ, who had been blamed for several capital bombings over the past 3 years in cities such as London, Abuja, and Ottawa. And this was also listed on the UNSC consolidated list. So this was a transnational terrorist group. Unless I may be of any further assistance.
Thank you very much. This completes the first round of arguments of the applicant. And it's my pleasure to now invite the respondent to take the podium and to address the court. I call on the agent of democratic state of Run of Style. I give you the floor, sir.
Mr. President, Your Excellencies, my name is Robert Clark, and I am joined today by my learned co-agent, Ms. Sarah Purvis, on behalf of the respondent in this matter, the democratic state of Ranatsayo. I shall be speaking for 22 minutes, Ms. Purvis for a further 22 minutes, and we respectfully reserve 1 minute for Sarah Buttles. Mr. President, Your Excellencies, On the 3rd of June 2018, Ms. Vormund, a whistleblower, claimed that Aproplia had failed to transparently report suspected cases of Javid-18 and was subsequently pursued by Aproplian police. In those circumstances, Ranastau sheltered Ms. Vormund at its consulate in Segura province and applied its entry regulation to Aproplia for fear that it was failing to properly manage the virus outbreak. I'll be making submissions in relation to the application of the entry regulation and the matter of Ms. Vormund, and my learned co-agent will address the Ranastau counterclaim. Turning first to the application of the entry regulation, the applicant made two submissions, and they were first, that Ranastau violated international law in applying its entry regulation to Aproplia, and those obligations cited were first Article 43.1 of the IHR, and second, prohibitions on discrimination in both the ICCPR Article 26 as well as the IHR Article 42. And the applicant's second submission was that Ranastau was therefore obligated to pay compensation. In response, we submit first that Ranastau violated none of these obligations, but that second, even if it did, it should not be obligated to pay compensation. Turning first to our submissions in relation to Article 43.1 of the IHR, the applicant submitted that Ranastau violated this obligation by applying its entry regulation to the entirety of Aproplia in circumstances where there was a reasonably available alternative, less restrictive of international traffic, that would have achieved the appropriate level of health protection. The applicant, on their submission, stated that that alternative was applying the entry regulation solely to Segura province. Before addressing that alternative, I would first turn this court's attention to characterizing the appropriate level of health protection. We submit that that should be done with regard to the totality of evidence before this court as to Ranastau's approach to the Javid-18 pandemic. And this approach is consistent with the World Trade Organization's characterization of states' appropriate levels of protection in the context of the Agreement on Sanitary and Phytosanitary Measures. For example, in the 2016 panel report, the case of Russia pigs, paragraph 7.739. On the totality of evidence, we submit that Ranastau's appropriate level of health protection was to prevent the entry of anybody into Ranastau who, as a real possibility, may spread Javid-18 to the Ranastauian community.
Excuse me, Agent. Can I ask you a question? You refer to WTO's cases, but here in this case, you really have to address the question of the recommendations from WHO. How you see the legal effect of the recommendation from WHO?
Of course, Your Excellency, we submit that the recommendations by the World Health Organization are non-binding, and that is how they are defined in Article 1 of the IHR. And indeed, the entire purpose of Article 43 is to provide for states to adopt additional health measures which exceed the recommendations of the IHR, as is provided for in Article 43. So here, we submit that the appropriate level of health protection sought by Ranastau in excess of World Health Organization recommendations was to prevent the entry of those individuals I specified earlier. And that is because of two pieces of evidence. First, the statement of President Kaukan at paragraph 11 of the Agreed Facts, where she explicitly outlined the purpose of the entry regulation, which was to prevent the entry of anyone who may be carrying the virus. And second is the evidence of the widespread application of the entry regulation at paragraph 16 of the Agreed Facts. We know it was applied to 52 states within 1 month of it being adopted on the 22nd of April. Based on that characterization, we submitted the alternative put forward by the applicants applying the entry regulation to Segura province alone would not have achieved Ranastau's appropriate level of protection. The applicants, in support of their alternative, pointed this court's attention to the regional lockdown of Segura province implemented on the 5th of June at paragraph 27 of the Agreed Facts. And the applicant claimed this was evidence that Javid-18 could not possibly spread outside of Segura province. However, I would like to draw this court's attention to the fact that the first suspected cases of JAVID-18 in Segura province were tested on the 25th of May, 10 days prior to the regional lockdown. And during that period, as the Afro-European government itself admitted at paragraph 24 of the agreed facts, the Afro-European government took no precautionary measures. Indeed, it did not even implement universal testing, as is recorded at paragraph 37 of the agreed facts. And in those circumstances, there was a real risk that the JAVID-18 virus had spread outside of Segura province prior to the implementation of the regional lockdown on the 5th of June. And therefore, allowing travel from those parts of Afro-Europe would expose Ranostyle to the real risk of people entering the Ranostyle community capable of spreading the JAVID-18 virus, notwithstanding that no cases outside of Segura province had been recorded at that time. In addition, Ranostyle was particularly vulnerable to travel from Afro-Europe because, as is noted at paragraph 34 of the agreed facts, there was a particularly high volume of travel of individuals between Afro-Europe and Ranostyle. On that basis, we submit the alternative put forward by the applicants would not have achieved Ranostyle's appropriate level of health protection.
Excuse me. Let me go back to the question of SPS agreement and the WTO jurisprudence. Well, SPS agreement, let me go back to the GATT. GATT Article 20 B, necessary to protect human life or health. And this necessity test has been interpreted very, very strictly. And SPS, similarly, I think the requirement is very strict. So if you invoke WTO jurisprudence for your argument, it works to your disadvantage, doesn't it?
No, Your Excellency, on our submission, it does not. And that is because the necessity of any measure under Article 5.6 of the SPS, and by extension under Article 43.1 of the IHR, must be measured as to the availability of alternative measures that could equally achieve that state's appropriate level of health protection. And therefore, in the absence of an alternative that the applicant can put forward that would achieve Ranostyle's appropriate level of health protection, we submit that in fact was necessary to bar travel from the entirety of Afro-Europe because that alternative would not meet the appropriate level of health protection. Turning next to the applicant.
If I may ask you, apologize on this point. In case that we do not accept your view that recommendations are not binding, would it be possible still to justify the measures you have adopted by state of necessity under rules on state responsibility?
No, Mr. President, we do not press any arguments in relation to necessity. We instead press our arguments in relation to Article 43.1. And in addition, we press arguments in relation to the applicant's submissions on discrimination under Article 26 of the ICCPR. The applicant's submission was that Ranostyle violated this prohibition on discrimination by distinguishing between Ranostyle citizens and Ranostyle permanent residents. However, as the Human Rights Committee has noted in its general comments number 18, paragraph 13, distinctions will not amount to prohibited discrimination if there is a reasonable and objective criteria for the distinction.
What is the legal nature of these general comments of the Human Rights Committee? I'm asking because there is nothing in the International Covenant on Civil and Political Rights about this kind of a role of the Human Rights Committee. It was originally intended that it would receive complaints and also reports of state parties about the implementation of the obligations. So what's the legal nature and what's the basis of the competence of the Human Rights Committee to issue general comments, thus purporting to interpret the covenant, please?
Mr. President, we would point you to this court's decision in 2010 in the Amadou Diallo case, where it stated that as the chief interpretive body of the ICCPR, the Human Rights Committee should be given great weight, and that was at paragraph 66 of this court's decision in that case. So here, there can be no discrimination as long as there was a reasonable and objective criteria. And we submit that it was reasonable in the circumstances to limit the number of individuals in Ranelstein quarantine, because every additional individual in a government quarantine centre increases the risk of transmission by, for example, human error from those facilities to the Ranelstein community. And in restricting the number of places in government quarantine facilities, we submit that it was reasonable for Ranelstein to prioritise its own nationals who, but for their ability to enter Ranelstein, may be unable to enter any other country due to Ranelstein not permitting dual nationality, as is noted in paragraph 3 of the agreed facts. However, even if this court is against us on the question of breach, we submit that Ranelstein should nevertheless not be obligated to pay compensation. We accept the test for...
Excuse me, Agent. You discussed the reasonableness and objectiveness, but isn't necessity again a requirement for this obligation and proportionality? You only talked about reasonableness and objectiveness, but does it have to be necessary and proportional? Thank you.
No, Your Excellency. The only requirement set forth by the Human Rights Committee in its general comment number 18 at paragraph 13 is that there must be a reasonable and objective criteria. And in addition, it must be in pursuit of a legitimate purpose under the covenant. However, that has been noted, public health has been noted as such a legitimate purpose. For example, in the 2013 case of Van Dam, Korea, at paragraph 8.5. However, even if
the measure must be necessary for the legitimate purpose. In that sense, necessity is required. Measure must be necessary to achieve the legitimate purpose. So the necessity is a requirement, isn't it?
Not on our submission, Your Excellency. However, in any event, we submit that it was necessary to achieve legitimate purpose because, as we noted, any additional individual in Ranelstein government quarantine would increase the risks of transmission into the Ranelstein community of a deadly virus capable of asymptomatic transmission with an exponential reproduction rate, as is noted at paragraph 7 of the agreed facts. Turning now to compensation, we accept the test put forward by the applicants that they must demonstrate a sufficiently direct and certain causal nexus between the breach they alleged and the harm suffered, as was the decision of this court in its 2007 decision in the genocide case at paragraph 462. However, our submission is that the applicants have failed to demonstrate such a nexus. The applicants relied upon in their oral submissions the report at paragraph 46 of the agreed facts by their own Ministry of Tourism. However, this report does not establish a nexus between the breach they allege, which is the application of the entry regulation, and the harm they purport to suffer, because the report at paragraph 46 attributes economic losses to the entry regulation since its inception, which is not the breach alleged by the applicant. And this is an important distinction because, as is noted at paragraph 30 of the agreed facts, and the applicant this, 80% of tourists in Acroplia departed prior to the application of the entry regulation, or even its announcement between the 5th and 7th of June, and therefore we submit there is no such causal nexus. Turning next to the matter of Ms. Bormond, the Acroplian whistleblower who claimed who revealed to the world the true status of the JAVID-18 outbreak, the applicants have submitted that Ranelstein violated the customary principle of non-intervention. However, we note, as this court found in the asylum case at pages 274 to 275, that there will be no prohibited intervention where there is a legal basis established for such an intervention. And here, Ranelstein relies on a customary international law principle, allowing states to grant diplomatic asylum on humanitarian grounds. And therefore, the critical question for this court is whether that custom exists, and if it does, whether Ms. Bormond would qualify for its grant. Turning first to state practice, we accept the test put forward by the applicant, which is that it must be widespread and uniform. However, the applicants did not clarify.
Excuse me, Agent. I'd like to point out one thing. In your written pleadings, you are talking about referring to a number of states' practice. On page 14 of your written pleadings, if you may notice, there you refer to the Republic of China. You are pleading in front of the ICJ, the principal judicial organ of the United Nations. You should know this General Assembly Resolution 2758. The full name China should be the People's Republic of China. And I assume you may not be aware of this mistake, but I hope from now on you will keep this in mind. It's very important to plead in front of the court in conformity with the General Assembly resolution. You may please go on.
Yes, Your Excellency, we do know that that was an error, and we do not press our submissions in relation to that. And we note that the People's Republic of China has previously granted diplomatic asylum to protesters in Albania in 1990. Turning then back to the issue of widespread and uniform state practice, we note the International Law Commission's 2018 draft conclusions on the identification of customary international law that stated that what amounts to sufficient state practice will depend on the nature of the custom asserted. And so here we submit that the at least 45 states which have granted diplomatic asylum on humanitarian grounds is sufficient to make out such a widespread and representative practice, because the granting of diplomatic asylum by its nature falls outside of the scope of a state's regular diplomatic relations and is therefore not frequently engaged in by its very nature. In particular, Your Excellencies, we submit that this practice should be given weight, given that it includes the practice of all 15 states with the most number of consulates and embassies, who are therefore most likely to be approached by individuals seeking diplomatic asylum and are specially affected by the existence of the custom. The applicants in their oral submissions took particular issue with the granting of asylum to Julian Assange by the Ecuadorian embassy and cited the United Kingdom's statement and its practice in relation to that, opposing the right of Ecuador to grant asylum in that case. We note first that 12 states in the Union of South American States affirmed Ecuador's right to grant asylum in relation to that matter. But in relation to the United Kingdom's practice, we submit that consistent with this court's approach in the 2012 decision of jurisdictional immunities of the state at paragraph 76, the United Kingdom's practice should be assessed as a whole. And therefore we submit that because the United Kingdom has consistently granted diplomatic asylum in 1941, in 1984, and in 1988, that this practice is not outweighed by one instance of it opposing the grant of diplomatic asylum. Turning next to the question of opinio juris.
Let me ask you one more question on this. You are talking about custom international law. We understand that you not only have to talk about state practice cases you refer to, you have to show us the evidence where you can find opinion juris on this.
Yes, Your Excellency, I'll turn now to opinio juris, and we rely on three pieces of evidence for opinio juris. The first is the 13 states that have explicitly stated before the United Nations their support for the existence of the custom. Second is the 12 states in the Union of South American States that explicitly stated that is a right for all states to grant diplomatic asylum. And third is the 45 states which have practiced the grant of diplomatic asylum because they have done so openly and because they have done so without apology. By its very nature, this practice has been conducted in such a way that evidences a belief in a legal entitlement, which is the standard of opinio juris set forth by this court in its 1969 decision in the North Sea continental shelf cases at paragraph 77, and that therefore there is sufficient opinio juris to support the existence of a custom. And if this court is with us on the existence of a customary entitlement to grant diplomatic asylum on humanitarian grounds.
Excuse me, Agent. You don't refer to the asylum case very much in your pleadings, but can you remind us what the court said in that decision? Didn't the court deny the existence of universal custom on diplomatic asylum?
Yes, Your Excellency, that is precisely what the court found in the asylum case. Our submission is that the custom has developed since then, particularly with the practice of states during the fall of the Eastern Bloc in the late 80s and early 90s, where diplomatic asylum was frequently granted, such that a custom exists in 2018 when Ms. Vormund arrived at the consulate in Segura province. And we submit that Ms. Vormund was eligible for the grant of asylum because there was reason for Ranavsayo to believe that she faced a deprivation of her liberty because of her expression of a political opinion. Ms. Vormund's offending conduct was the publishing of a tweet at paragraph 18 of the agreed facts that criticized the Approprian government and accused it not only of covering up the spread of the virus, but also of an indifference to the lives of its citizens. For that, Ms. Vormund was charged with 3 charges, all of which she denied, and she claims that they were only brought against her to shut her up, in her words. And it is not clear to Ranavsayo she committed them, and in those circumstances, there were reasons to believe she faced such a deprivation of her liberty. If I may be of no further assistance to the court, I will defer to my learned co-agent, Ms. Purvis, to continue the submissions for the respondent. May it please the court.
Thank you very much, and I invite now the co-agent, Ms. Tara Purvis, to continue in the presentation of the arguments of the respondent and also counterclaimant. You have the floor, madam.
Mr. President, Your Excellency, I will be continuing the submissions of the respondent in addressing first the jurisdiction of this court to hear Ranavsayo's counterclaim, and secondly, the counterclaim's merits, namely whether the applicant has violated international law in the shooting down of the Mantian Airways aircraft. The relief that the respondent seeks is that this court has jurisdiction and that the applicant violated international law. First, on the question of jurisdiction, the applicant has deposited a declaration accepting this court's compulsory jurisdiction, as noted in the Statement of Agreed Facts at paragraph 48, and this declaration contains a reservation. We accept the applicant's submission that this reservation contains 2 conditions. First, that this declaration shall not apply to any disputes concerning Approprian military activities, and second, or to any disputes with regards to matters which are essentially within the domestic jurisdiction of Apropria as determined by their government. And we accept the submission that the self-judging aspect of the reservation applies solely to the second half or the second condition within the reservation. Turning first to the question of the automatic reservation, there are 4 primary issues that have been raised by the applicant's submission. First is the validity of an automatic reservation. Second is whether automatic reservations can be invoked in good faith. Third goes to the severability of the self-judging clause. And fourth is whether or not, if severable, this would fall objectively, essentially within the domestic jurisdiction of Apropria. First, on the invalidity of the self-judging clause and the automatic reservation, we submit that such self-judging clauses are invalid because they are contrary to Article 36.6 and Article 36.2 of this court statute. Briefly addressing the applicant's submissions on Article 36.6, they noted, or their primary submission was that Article 36.6 has been invoked or can be validated here because it allows the court to settle a dispute. And here, it is our submission that that is not the case because the use of Apropria's reservation would mean that this court can only register the settlement of Apropria's settlement of a dispute, and that is contrary to Article 36.6. On our primary
If I may interrupt you, but my understanding is that the applicant says that the court, the basis of compétence de la compétence, can still consider this reservation, whether it has been invoked, reservation relating to domestic matters as determined by the government, whether this invocation has been made in good faith. So it's not the position that this court cannot look at the reservation, but it has been validly invoked in good faith. What's our argument against this position?
Mr. President, our argument on good faith goes to 3 points. First, we submit that good faith principles cannot apply to optional clause declarations, especially self-judging reservations, because the natural and reasonable reading of the words as determined by appliquia means that such determinations can be arbitrary. And the principle of the interpretive principles for reading optional clause declarations must consider the natural and reasonable reading of the words that have been actually used in the declaration. Here, as Judge Lauterpacht noted in his Norwegian loans separate opinion in 1959, my apologies, Your Excellencies, he noted there that determinations can be made arbitrarily. And this is contrary to the applicant's submissions and their reliance on Judge Reed's separate opinion in the Norwegian loans decision. And they relied on page 94 to substantiate why good faith principles can apply to declaration. Yet, at page 97 of his same separate opinion, he notes that any application of a good faith principle in that situation is contingent on the words of France's reservation, that it was to be understood as what was essentially within the domestic jurisdiction of the court or of France was to be understood by the government of France. And the words and understanding can be read in good faith, whereas determinations are arbitrary in nature. On that basis,
Agent, excuse me. Given all facts, evidence before the court, don't you think this matter really lies within the domestic domain, given the facts?
No, Your Excellency.
Why? What's your analysis?
Our reason for why this is not essentially within appliquia's domestic jurisdiction is because this matter is governed by international law, and as noted by the predecessor to this court in 1923 in the advisory opinion concerning the nationality decree in Tunis and Morocco at page 26, they noted where there are matters that prima facie are regulated by international law, whether or not that is customary or based in treaty. Those are not matters that can be objectively or essentially within one state's jurisdiction, domestic jurisdiction. And here we submit that appliquia has breached 2 treaties to which they are party, 2 international conventions, that being the Chicago Convention and that being the ICCPR. Returning then to why other principles of the principle of good faith does not apply to self-judging clauses, we submit that that is because the court cannot read words into optional clause declarations because they are sui generis, unilateral acts of state sovereignty, as noted by the court.
How these unilateral acts are to be interpreted? What are the rules for interpreting unilateral declarations?
It is to be interpreted as to what the intention of the state at the time of making their declaration, Mr. President. And that is noted by this court in 1998 in the fisheries jurisdiction decision. Here, we submit that no intention has been evidenced by the applicants here, and that in all the circumstances here, reading the words of their declaration, that is as determined by appliquia, that does not confer an intention of good faith because the natural and reasonable reading of the words as determined can be arbitrary. Lastly, the applicants relied upon Nicaragua and the decision there at paragraph 60 in order to substantiate why a good faith principle may apply. And we submit that cannot be the case because at paragraph 61 of the court's decision there, they noted that that was based on the temporality of the United States Optional Clause Declaration and is therefore not analogous here. Therefore, principles of good faith cannot apply to these kinds of automatic reservations. Next, we submit that because these principles, or these optional clause declarations cannot be read in good faith, they must be invalid because they are contrary to Article 36(2) of this court statute, because they are illusory reservations and conditions of consent. And as noted by Judge Guerrero in the Norwegian loans decision at pages 68 to 69, such reservations must be devoid of all legal validity because it is not possible to establish a system of law if each state reserves to itself the power to decide what that law is. Here, we submit then that the last aspect of Apulia's reservation, as determined by the government of Apulia, therefore must be severable. Because
if we accept that this reservation is invalid, has this any implication on the declaration as such? Because you told us earlier that in interpreting the declarations, what is important is the intention of the state which has made the declaration, because these declarations are unilateral acts. So what's the implication of the finding of invalidity of the reservation on the validity of the declaration itself, please?
Mr. President, we submit that this reservation can still be valid if the last aspect, the self-judging clause, is severed. And that is because it is a rule of optional clause declaration that texts that emanate from a government must be interpreted as intended to produce effects in accordance with existing law, as this court noted in its 1957 preliminary objections to the rights of passage over Indian territory at page 142. And therefore, we submit that that last clause can be severable, which brings it in line with the 23 other states which have reservations, which denote the conditions of their consent, excluding disputes with regard to matters which are essentially within their domestic jurisdiction, but not with the self-judging aspect. As such, we submit that Apulia cannot rely upon their automatic reservation in order to preclude this matter. Briefly on the military activities reservation.
Agent, excuse me, you haven't explained fully. If, as what you said, the declaration made by the applicant remains in force, there still could be the question whether the matter lies within domestic domain. And do you think this is the case?
No, Your Excellency. And that is because, as noted in the predecessor to this court in the advisory opinion on Tunis nationality decree between Tunis and Morocco, where there are concerns or allegations of breaches of international law and international treaties, and those areas are regulated prima facie by international law. We submit that this is one such occasion where it's regulated by Article 3B of the Chicago Convention and Article 6 of the ICCPR. It cannot, therefore, be within the domestic jurisdiction of one state. Briefly on military activities, we submit that a natural and reasonable reading of the terms applicable military activities would place military as a descriptor to the word activities. And therefore, the submissions made by the applicant as to their definition concerning that any activity done by the military would be excluded cannot be valid. That is because, as noted in very similar reservations to treaties under the UNCLOS regime, Article 298(1)(b, their interpretation of the word military activities was taken to take into account and must be primarily on an objective evaluation of the nature of the activities in question, taking into account the relevant circumstances of each state. And that comes from the interpretation of the word military activities within the UNCLOS regime in 2019, the ITOS Tribunal Division in Ukraine and Russia. Here, taking into account the primary purpose of the activities in question, they were a law enforcement one. And that is because they are akin to a Coast Guard activity, where the Appupulian Air Force was merely regulating who could fly over, who could enter Bhutan airspace, and as such was a law enforcement was of a law enforcement nature and therefore not a military activity.
Yeah.
Turning then to the substance of the counterclaim, we submit, or the applicants have submitted here, that there are two reasons why the Chicago Convention cannot be invoked here. And first is because it does not apply to domestic flight, and second is that any breach of 3bis would be precluded by circumstances of self-defense. First, on the application of domestic flight to, or the application and the applicability of the Chicago Convention at first instance, we submit that the Chicago Convention does apply to domestic flight. First of all, we would like to note that this, the Manhattan Airways aircraft was not a domestic flight. It was flying towards Bogdayo in Ranastayo. Yet, even if it was considered a domestic flight, taking into account the object and purposes of Article 3bis of the Chicago Convention, as noted in the 79th ICAO session, document number 9073, and minutes of that plenary session, many states there noted that the adoption of Article 3bis merely formulated or merely clarified the existence of a customary rule of international law, ensuring that there should be no use of weapons or force against civil aircraft in flight. And that is reflected in the text of Article 3bis, that is, as it is not textually restrictive. That protection...
Let me ask you a question. As in your analysis, you don't think this is a case relating to terrorism, given the fact before the court that Interpol already warned there are terrorist groups active around in that area. In that circumstances, given the case 911, how you explain this case, this flight would not pose imminent danger to the applicant country? How do you explain that?
Your Excellency, it is our submission that this flight never posed an imminent threat because objectively, on the facts, as noted at paragraph 43 of the Statement of Agreed Facts, there was no weapons or no weapons and no bombs on this aircraft. That is because it was not a terrorist threat that was headed towards Bhutan. Indeed, Ms. Hai and Ms. Wilmond were not even trying to reach Bhutan, they were trying to reach Bogdayo. Here, that goes to whether or not these kinds of perceptions of a victim state acting in purported self-defense can be considered in the question of anticipatory armed attack. And on self-defense, we note that there are two primary legal questions for this court to consider. First, whether or not the existence of an actual armed attack is required. And second, whether or not actions undertaken by non-state actors can be accounted for in the prerequisites to Article 51 self-defense. On the existence of an anticipatory armed attack, we submit that the actual wording of Article 51 is restricted there because it states that nothing, that the present charter, that this existence of the right to self-defense exists only if an armed attack occurs. That requires the actual objective existence of an armed attack. And here, there was no existence of an armed attack. That is clarified by this court twice, first in 2003 in the oil platforms decision at paragraph 73.
Excuse me, Agent. You draw attention to the wording, but the text says armed attack occurs. It doesn't say armed attack has occurred, right?
Yes, Your Excellency. However, we submit that the word occurred indicates that this must be a factual reality, and that is supported by two decisions of this court. First, in the oil platforms decision of 2003 at paragraph 73, where any requirement of self-defense must be one that is strict and objective. And again, in the 1984 Nicaragua decision at paragraph 195, where it's reliant on the actual existence of an armed attack. And to that extent, we submit that because there was no existence of an armed attack, that prerequisite cannot be satisfied. On the question of...
I apologize for interrupting you, but in case that there is a perceived risk of attack, has the state any legal options how to prevent that attack by taking appropriate measures? When the threat is imminent, you know, the plane is already flying in the air, and the state has a perception that it's aiming at important buildings in its capital. So what action could that state take?
Your Excellency, we submit that that cannot be, and there cannot be actions under Article 51 self-defense. It may be under a different circumstance that would preclude any wrongfulness of their actions, such as those circumstances outlined within the Articles on State Responsibility. However, the applicants have only alleged Article 51 self-defense in order to...
No, agent, regardless of the legal basis, can the applicant did that on the basis of national security?
Your Excellency, we submit that there was no threat to national security at all. And that is noted because there was no weapons or bombs on the aircraft. And as such, because the requirements for self-defense...
How did you know? It's only in hindsight, you said there's no bomb. How did you know that? When all the preventive measures were taken by the applicant Air Force, how could you explain? Only you can't say it in hindsight.
Your Excellency, we submit that the applicant could have done more to be able to ascertain the exact nature of this threat. And as Special Rapporteur Kalamar noted in her report to the Iranian government on the 23rd of February earlier this year, concerning their shoot down of Ukrainian flight PS-752 in January 2020, there were measures that could be taken by any state alleging self-defense in order to ascertain the existence and the imminence of the attack. And that includes considering whether or not this aircraft posed or had hostile intention. We submit, well, as noted by the German Constitutional Court in their consideration of the aerial security law in 2016, at paragraph 149 of their decision, they noted for a plane to have hostile intent, there must be certainty as to the elements of that offense. And there was no certainty here. Indeed, Special Rapporteur Kalmar noted that many precautions could have been taken by Israel before that would have been able to preclude their wrongfulness of shooting down Ukrainian flight PS-752, including doing things like alternative means of diverting the aircraft, as well as using precautions in securing their airports. And we submit here that those precautions would have been reasonable. That is because Segura was in lockdown. It was entirely feasible for Aquaplia to be able to enhance security where there was a feasible risk of terrorist attack. And the fact that they did not goes to partially why self-defense would not be available to them. On other measures that they could have taken in flight, we submit that similar to the situation in Washington on May 24th, 2005, where a small two-seater aircraft flew into Washington and was unresponsive 2 minutes away from the national capital, where they were eventually diverted through the use of other means of interception, including afterburner and reheat. Those measures could have been used by Aquaplia here to divert the Mantian Airways aircraft.
Your time is up. Maybe I give you 20 seconds to complete the presentation of your claims. Yeah.
Thank you, Mr. President. In that case, we submit that because Aquaplia did not take those reasonable measures, therefore they are not enabled to rely upon necessity and proportionality in completing the requirements under Article 51 of the UN Charter, and therefore they have breached Article 3 bis of the Chicago Convention. If I may be of no further assistance to the court, those are the submissions of the respondent.
Thank you. This completes the first round of oral argument of the respondent, and I will now invite the applicant to present rebuttal arguments, the second round of oral arguments by the applicant. You have reserved 3 minutes for this task, so I invite the agent to address the court, please. You have the
Thank
floor,
you,
madam.
Mr. President. Thank you. President, Your Excellencies, 2 points in rebuttal. First, regarding pleading 2, agent for the respondent argued that there exists a customary exception to the non-intervention customary rule, relying primarily on act of asylum to Mr. Julian Assange. At page 276 of this court's 1950 asylum decision, it was stated that what is required is for the respondent to provide proof of constant and uniform state practice, evincing, and I quote, a right appertaining to the state granting asylum and a duty incumbent on the territorial state to respect such granting of asylum. In respect of Assange alone, Ecuador's decision was rejected as unlawful by the territorial state as well as the US. Foreign Secretary of the UK stated, and I quote, the UK does not accept the principle of diplomatic asylum. It is far from a universally accepted concept. And even in the granting...
I apologize, but what's your view, what's your answer to argument that in the past, for instance, the United States at its embassy in Budapest for some 15 years provided asylum to a person?
Cardinal Vincenti, Mr.
Yes.
President, indeed, that
Correct.
is true.
Yeah.
However, Your Excellency, precisely, Mr. President, the fact that the US itself has vacillated in its position on whether diplomatic asylum is lawful shows that it only granted diplomatic asylum out of political expediency rather than any rule grounded in international law. And therefore, we submit that the respondent has failed to show such existence of a customary exception at international law. And even in the granting of asylum to Mr. Chen Guangqing, the People's Republic of China criticized it, and through its foreign ministry spokesperson, stated that it does not recognize diplomatic asylum at international law. Second point of rebuttal, Your Excellencies, regarding issue 4. Now, the respondent asserts that there is no right of anticipatory self-defense. This is incorrect in law. The respondent has omitted the wealth of state practice. For instance, Turkey and UK's 2019 and 2015 invocation of Article 51 against ISIS, citing the need to respond to imminent armed attacks. And Your Excellencies, the respondent's position is unconscionable and impractical as a matter of reality. States cannot be expected to be sitting ducks in the face of an imminent attack. Your Excellencies,
very much. This really completes the second round argument. The court takes note of the arguments and the submissions. And now I invite the agent or co-agent of the region. So I give Mr. Clark, you have the floor.
Thank you, Mr. President. 2 points in reply. First, on the existence of a custom, the respondent relied on the practice of 45 states, including 15 specially affected states, and in relation to states accepting the granting of asylum as a duty incumbent upon them to acknowledge, that has been represented in the practice of states. For example, Lebanon, the Mauritius, Zimbabwe, and Guinea all accepted the granting of diplomatic asylum by legations in their territory as lawful. Second, in relation to anticipatory self-defense, the respondents do not submit that there is no right to anticipatory self-defense. The respondent submits that there must be an objectively existing armed attack, as was noted by this court in oil platforms at paragraph 73, and in relation to the practical consequences of that, as the International Law Commission has noted, States invoke circumstances precluding wrongfulness at their own peril if they make a mistake. May it please the court.
Thank you very much. This completes the second round of arguments of the respondent. The court takes note of these arguments and the final submissions. As there is no further business, I declare this sitting closed. The court is going to retire in order to start its deliberation. The registrar of the court will inform the agents of the date when the court will deliver its judgment. The sitting is closed.
The Honorable Court is now adjourned. The judges will now exit the courtroom to deliberate and will inform the parties when they are ready to return to the courtroom to deliver their judgment.
Judge Tomka, you can proceed whenever you're ready.
Thank you very much. I declare the sitting open. The court meets today to read its judgment in the case concerning the COVID-18 pandemic, United Republic of Après-Pluia against the Democratic State of Rano-Style. The court has deliberated, appreciated very much the strong arguments of both parties, which have demonstrated excellent knowledge of international law, capability to respond to questions, and address the arguments of the other party. The court has decided unanimously that the best oralist is Ms. Jia Wei Bei. I congratulate her. Concerning the case, the court has decided that the University of Sydney has prevailed, and I congratulate the University of Sydney on winning the competition. And I extend also my appreciation to the first runner-up, National University of Singapore.
Thank you very much.
I am sure that international justice has a bright future with this young new generation. And as I said to my colleague during our deliberation to Judge Xue, I have no doubt that the day is approaching when women will constitute the majority on the bench of the World Court. I congratulate once more both teams and other teams which have participated in this competition, because we were told by organizers that that was extremely high level of competition, excellent knowledge of international law. And I also wish to thank organizers to have prepared this year competition named after a great American judge of the International Court of Justice, Philip Jessup, who served on the bench of the International Court of Justice since 1961 to 1970. Thank you, and the sitting is closed.
Thank you very much.
Bye-bye.
Thank you, Your Excellency.
Thank you. All the best.
Oh, congratulations.
Congratulations. Okay.